Informed consent and waiting requirements constitute insurmountable barriers to prevent access to abortions. Riley 96. 1 of 5 U.S. women seeking abortion without shame and press for change legislation such as burden for informed consent requirements waiting periods. 84% of U.S. counties have no abortion provider. It seems unlikely most decline abortion levels due to reduced numbers of unintended pregnancies. Accessibility of abortion service seems to account for significant part of the decrease of increase in legal issues such as waiting period. Number of facing insurmountable barriers is likely to increase the rhetoric of voice rhetoric availability of permission to access is also enabled others to choice to support laws and policies to women's access to abortion services and takes informed consent requirements for taxes employment and states control populations manipulate women. She in 97. Justice definition of women's abilities right to make decision mistrust women's decision making ability and their sterile notion of how decision must be made in an equitable result the informed consent provision on these decisions with the pregnant woman before she hope to make that decision. The justice willing for the contributions of all pregnant will be safe with the informed consent provision will save you greater waste of family reform to make a decision. Thus, ensuring that this mature informed justice spiritual legal framework reveals how deeply they confuse the pregnant woman's decision about abortion with their own justice, not acknowledge that the women can have made a decision worthy consideration before arriving at the clinic or she's been outside the law. Her decision is held no more weight than the initial inclination of judge, jury, point, political specific arguments and evidence before the pregnant woman can be allowed to make a decision which shall let the state of press preference for normal child birth things be printed off philosophical social arguments be brought to bear favor of pregnancy to full term the injunction of the representation is entirely one sided, not mean entertains the lens the information offers truthful, not misleading after presentation of arguments against abortion reasonable framework corresponding weight at least a day before deciding this important decision be more informed and deliberative also the period of reflection of the woman the clinic has already made up her mind. She's not required to law frame the question presented for the losses framework for the decision making in terms of the question to be asked and the answer to be accepted beyond the law, however, even beyond the capacity of our language to express without fundamental distortion, even allowing that pregnant woman might need additional information. The law cannot say what that information might be. All language available to women has been developed to express the need and serve the ideas, needs, and feelings of men. A man's experience of pregnancy comes only from being born, never from giving birth. Men, the law cannot yet know what pregnancy is for women because it's not yet possible for any but the most extraordinary women to express these meanings in language that men can understand. The state's intervention in the Northern Clinic is aimed at ensuring the woman's choice contemplates consequences from the discipline point of view from which the law understands and improving the formal system justice allowed the state to inflict on the pregnant woman what the justice himself should recognize as psychological abuse. The judge's own language having to make women make a decision about abortion is for the very first time. The joint opinion for the joint opinion of the state, even now she's made a decision worthy of respect, she may be turned away from the clinic, forced to consider the state's arguments against abortion in order to decide the matter. Again, the pregnant woman may have spent much time to travel far. She may have struggled through the ring of protesters outside the clinic trying to overrule her decision, but she must return her infos full brochure to face them again and yet again. The way pregnant woman finds no refuge in the joint opinion and parental consent laws go a result of coercion and the denial of abortion rights. Schmidt 93, when judicial bypass provision parallel notice and consent laws may result in denial of abortion rights for the multiple consider preventing their daughter from obtaining an abortion. Judicial bypass hearing provides no guarantee the abortion of the young woman versus now of the right to terminate pregnancy. Parents may still block their daughter's access to abortion providers. Some parents impose an abortion based on religious and moral scruples. Some parents subject their daughters to financial, psychological pressure, and physical abuse. Some parents physically prevent their daughters from returning to abortion provider have procedure form and instant form notification laws severely restrict a woman's ability to obtain an abortion. There's evidence this is the purpose behind such laws, and record keeping requirements are also meant to urge people trying to get abortions dead. In 2001 state abortion policy and that the abortion procedures are burdensome and necessary record keeping is not opposed to other outpatient search for procedures for information survey and medical standards because it's used a potential source of harassment, intimidation, when we elect to have an abortion from the relevance of information, search and release of information. Anyone who wants to understand how law, this allegedly true motivations of parent from the original version of the Abortion Control Act, including for some lady inconceivable state interest in the board hour woman she's an abortion full color photographs of dead aborted fetuses, funeral decision of fetuses replete with death certificates. Such measures must be deemed reasonably calculated not only to intimidate women, but also to make administration so burdensome that many doctors and hospitals will forego performing such heavily and unnecessarily bureaucratized procedure. In cases in the ultimate expression of a political controlled population, the informed consent doctrine purports perfectionist vision of women's health laws objective to the norms and ethics of the dominant culture, and additional laws seek to colonize prenatal life under the guise of preserving and protecting the health of the population. McLean in 98. The crux of analysis of such measures probably seeks to ensure the woman considering and understanding the impact of the use of first person may later graph decision is sole form separate devastating psychological consequences protecting women's well-being. Even though this protection is envisioned to foster women's well-being and several ideologies of women at risk for serious psychological consequences for choice because they are ignorant about what abortion is. These procedures women might terminate pregnancies so they not understand the anatomical characteristics of the fetus. The abortion is the concept of terminating fetal life. This model lacks a solid foundation. Most studies suggest majority of women feel relief after abortion, few reverse decision. They just experience abortion even responsive decision and exercise more responsibility. Perfection, efficient wrestling, and support of model of abortion is trauma or psychological failure for women is also start with the mental approach to the question of what this decision foster women's well-being. Much public policy disfavoring penalized childbirth of women. Many women seeking abortion are young without substantial right of choice. They are branded as immoral and socially irresponsible, and their fatherless families labeled both a symptom and a cause of social pathology. The case opinion is not defending governmental position until the other basis for the women's health and awful observing because for this government's faith life and interpretation is that women in the name of encouraging responsibility require study fetal development consider arguments against abortion on the rationale choosing to remain unformed innovation responsibility of the fetus in the community, and this interpretation right to make the open decision not confer to a right to be enslaved in society's opposition to abortion. This government persuasion satisfy the requirements of energy toleration and toleration is respected for the government's scheme or UMKC is tantamount coercion, that it would be failed to meet requirements of empty toleration. Is there a plausible argument that the 24-hour waiting period would be cursed in some instances, particularly for poor women and women who would not have difficulty explaining their whereabouts, which have practical effect of delaying or preventing abortion? And these are the biopower's operation at level makes massacres vital. We sit on the other side is the atomic situation and wholesale genocide for COVID-19. There's been a parallel shift in the right to death. Death has now manifested reverse the right to social body, which are maintained health idea wars would never bloody happen. All never reported regime. This is a Holocaust of populations, form of power, death, and self-discount, part of power, to positive influence on life is endeavor to administer, optimize, multiply, project, and precise controls, complex revelation, more to the existence of everyone's entire population, mobilize, reverse, local, slaughter, measures, become violence, managers of life, and survival of body, raise so many machines, been able to wage some of the worst technology, war, thousands, and increases toward all destruction, power, disposable population, destiny, side power, guarantee, and continued existence, diseases, and questions about whether juridical existence of sovereignty was a biological existence of population, genocide, and degree amount of power is not because of reason to determine nature, right to build, because the power is situated and exercised level of life, species, race, large-scale phenomenon, population, planet. The United States Supreme Court will Planned Parenthood, Southeast Pennsylvania, and all be Robert Casey, and all the United States Supreme Court will requirements according to consent form, consent waiting periods, record being upheld or unconstitutional. These regulations, of course, attempt to control population by preventing abortion. The Supreme Court should overrule Casey on these issues, period 98. Ever since Casey declared 24-hour periods of abortions for constitutional, state legislation passed laws commission women freedom to obtain abortion, turn look faster behind these bills is insulting the message that women who take abortion are not competent to make that very decision comes across loud and clear, and those delivered in the guise of compassion and serving women's rights, well-managed and wise, disavowing women's constitutional right to abortion, for women, privacy, defense, seven women's thinking out of the society, brothers, and personal time, we can see the requirement, suing a woman walks into a doctor's office without having considered the ramifications of her pregnancy. This is not the case. A woman knows what she wants her body to endure, whether pregnancy or abortion. Doctors already have a legal duty to provide enough information and obtain informed consent requirements and still seem to use doctor perform abortion, not doing an active job obtaining informed consent. The woman who works in the other parties to be able to give informed 24-hour period seems arbitrary and let a woman sleep on it, as if she had not already done so. These steps should be the type of woman who seeks an abortion when undergo what is good be she would buy pairs of shoes, similar to which usually short-sighted uniform for women who can't see. These laws put an enormous burden on a woman's right to obtain an abortion. 24-hour periods and continuing clause against doctors to bring grade 2 for an attack on the abortion right. 24-hour periods designed to make the process of birth. So second part is attacking doctors who perform abortion provision allows simple names and the license perfectly dissuades doctors from providing abortion services because it is too risky. Legitimate state agencies this argument is bogus. Stevens for this one is sent the 24-hour period argument for this Commonwealth's interest two ways, either which is not just the original first. It may be argued that delay is justified with the fact it's likely to reduce the number of abortions. Second argument justify any form of abortion. Please stop school woman past second 24-hour delay for this Commonwealth interest ensuring women's decision is form and thoughtful. There's no evidence that the mandate delay benefits women is necessary to enable the patient to convey any relevant information to the patient. Delay in this series rest on the outward and unseeable assumption about the receiving capacity of women. We must reject the notion that a woman is less capable of deciding a matter of gravity. 24-hour waiting period is arbitrary. What this takes out one from one to the line. What the decent court members be able to recognize is that taken together, Bill 24 like the others like creating huge burden on women to seek abortion. More state require waiting periods. Women seek a child for reasons to obtain abortion. State does not require waiting for child doctor's office choice. For women who cannot afford a child for clinical question. If the state does not require waiting period, not affording abortion laws effectively push doctors out of the field and provide abortion. The Supreme Court should revisit Casey and the judge unconstitutional. Bill 24 is not unconstitutional because follows the statement. The Supreme Court said to Casey that a waiting period does not place an undue burden on the woman such that outweighs the state interest. Message dangerous message goes far beyond the right to have abortions. These women are not capable of making decisions themselves, and the government must oversee. Even women's most intimate decisions that women are not capable of coming to a voluntary and informed consent on their own, or with the help of their doctor. Says the doctors who perform abortions are not to be addressed the bills about controlling women, subjugating against the government, affirmation that women are inferior. And the Supreme Court should overturn the parental consent requirements in Casey Berman in 94. So journal system of by definition not to complete spare committee practical Americans which is some of my position to Karen over their abortion decision the court afraid that no fair ground exists and I help break my perfection with their intentions. The only rationale behind the bypass requirements which are going to the safeguard is vehicle to keep some last veggies of patriarchal authority over some women's reproductive right to use the court to go back and strike down the parental consent notification or provision in Casey. The Casey court based decision of patently illogical reason court fatal flaws and failure to intend to investigate perfection of my women seeking abortion was identified rectify the same to raise state versus married women's women's return to school and parental consent statute negates the constitutionality of all consent notification provision regardless of presence of bypass fees you make toward third party involvement provides no legitimate state interest while resapping the lives of unemancipated buyers seeking abortion and regulations meant to prevent abortion and misogynistic attempts to coercion meant to control all women, especially those with limited resources, the races, classes, performance, women's reproductive status, and claim selfishness as justification for denying basic rights of women. Pride 98. Anti-abortion activists understand for taking actions young women die in public funding strategic ways. Isolated stigmatized doctors perform abortions, hospitals and clinics provide abortion, and the women who have abortion. Anti-abortion has been able to portray women having abortion selfish, sexually responsible, and feeling morally blind individuals who kill their own children can be used sleep and opportunities to make major moral decisions must be controlled. Careful women, especially those that produce resource blades of this big. Conservative programs such as that gender tax and welfare legislation and young local women will cover scapegoats. Conservatives propose solutions for serious house being endorsed and measures designed to control the lives of reproductive capacity of poor women. These proposals derive from analysis. Poverty is caused by poor women having too many children, not by racism, sexism, or lack of jobs.
Okay, you know, a lot of your evidence talks about the importance of this hurting woman. What's a woman?
Well, our evidence talks about the capacity to reproduce.
That's what a woman is?
Our law affects pregnancy. That's all our evidence says.
Women are determined by
No, our evidence talks about women who can become pregnant. It doesn't just generalize. It talks about how women who can become pregnant are the only ones who can experience birth. It seems to be, you know,
so under
women who can become pregnant.
So
probably
I was playing under what conditions are states allowed to regulate abortion?
You mean under what conditions?
Under what conditions are states allowed?
Are you asking about how the plan would affect the undue burden standard?
Yeah, sure. What would the plan do?
We're merely striking these down as unconstitutional. Our first piece of solvency evidence says that would restrict the ability of states to implement
So
laws
you
that
do or
restrict
don't strike down?
access. We strike down those statutes.
Okay. Is what do you?
And our solvency evidence
What would
says
you
that what that
replace?
causes, it prevents states
Sure.
from
sure.
implementing other restrictions.
What would you replace the undue burden standard with?
We don't specify that in the plain text.
Specify, but there's no standard. You just say they can't do these 4 restrictions.
Struck down as unconstitutional. Our solvency evidence talks about how that gets implemented, saying
Sure.
it functionally removes the ability of
Sure.
the state to
Do you
make
have
that
any
standard.
spillover evidence in the 1ACL why the plan would affect other areas of reproductive rights? I mean, your Riley
Give me
evidence.
some examples.
Sure,
of other areas of
your
reproductive
Riley
rights.
evidence in multiple parts talks about the importance of lack of funding. It says non-funding, declining service, fewer providers, attacks on clinic and providers are
Yeah, and our first
huge
piece of
questions
evidence
for
we read in the
abortion.
1AC says
That's
that all of
this
that
part.
is, yes, it says that all of that is due to the fact that there is restrictive
I mean, this
legislation.
makes it. This
People are
part-
less willing to fund abortion clinics if they know that they aren't going to be able to function. Doctors are less willing to work at abortion clinics because they know that they're not going to be able to function.
There's like 0 abortion clinics in the status quo, I think.
Well,
I'm
our
not
evidence
sure.
says, I don't know what percentage, but it says there's a shitload of counties in the country.
Sure,
that
I mean,
have access.
this
It's
part
like-
talks
I mean,
about
Kansas City is a major
I
metropolitan area of a
understand, but
million
your
people.
evidence
There's
talks about
one
the
abortion
importance
clinic
of
45
attacks
miles
on
away.
clinics and providers. The evidence makes a distinction between counties that don't have any providers whatsoever because of the fear of a cultural backlash. How would plan change those questions?
No, that's one factor. It also talks about how the reason that all those backlashes are allowed to occur is because the political thinking in the Supreme Court is that we should restrict a woman's access to
So,
abortion.
anti-abortion people, their entire thought process is dictated by Supreme
No, it's
Court.
not about that. We're not saying that we're going to end people protesting abortions, but
Okay.
our evidence is very explicit about how saying that all of this, the reason that this is allowed to continue to happen is because of structural problems in the way that constitutionality has been decided.
I mean, you make your biopolitics impact. I mean, y'all aren't claiming to solve or end all forms of violent biopolitics, right?
The affirmative is an isolation of a specific kind of biopolitics.
Yeah, the affirmative stance is going to be that the judges should reject the idea that we should subjugate women
Okay.
to men.
The order is 3 often in the case.